You're watching Bloomberg Law. I'm Pacchia. There were fireworks on display in Delaware Chancery Court a couple of weeks ago when Judge Leo Streen rebuked investment banking firm Goldman Sachs for the way it handled a potential conflict of interest in advising natural gas pipeline operator El Paso in rival Kinder Morgan's $21 billion bid for the company. The entire episode has led to a reevaluation of how investment banking firms should handle conflicts of interest. Joining me now to sort this all out, I'm happy to say we have John Reed, partner in DLA Piper's corporate and litigation groups. He's fresh off a panel discussion on this very topic here at Bloomberg headquarters, and we're happy to have him stick around and fill us in on this issue. John, thanks for coming in. Welcome.
Thanks for inviting me.
So before we kick off here, let's get the latest on this deal. Some shareholders are extremely angry that Goldman stands basically on both sides of this transaction. They're up for a $20 million fee for advising El Paso, and at the same time, the firm has a $4 billion stake in purchaser Kinder Morgan. The argument essentially is that Goldman, in its role, stands to benefit essentially if Kinder Morgan pays a lower price for their target. Where are we now in terms of this deal? Is this issue going to stop this deal from going through?
Well, that conflict was precisely what drove the litigation in Delaware. And the court's opinion was very clear that the stockholders now know about that conflict. And absent another bidder coming along, the court was going to let the shareholders decide. And a majority of the shareholders have decided, in the face of the conflict, to accept the transaction.
Yeah, quite a rebuke from Chancellor Strine. He called this an incomplete and inadequate handling of a conflict of interest, yet he let the sale proceed. Were you surprised by this?
Well, you had something akin to, I think, was a 47% premium. Mm-hmm. The premium was very, very high. And there was no indication that there was going to be another bidder come along. And so he was faced with a situation, am I going to kill this deal? Might not get back on track, and then the stockholders are going to lose out entirely. Mm-hmm. And I think what you're going to see in Delaware is a real hesitancy to enjoying these types of transactions unless there's an alternative bidder out there.
Well, ultimately, the shareholders can kind of decide what they want to do. So,
and that's really the point. The shareholders always can decide. Mm-hmm.
And also, money damages aren't quite off the table as of yet. Do you think that something like that could come to pass in this situation?
No, they're not quite off the table. The Chancellor expressed a lot of skepticism as to how that would ultimately be handled. Mm-hmm. I strongly suspect that this case might ultimately be settled so that those issues are never confronted.
This is a really interesting situation. I don't think I've ever quite heard of something like this happening, a firm being so conflicted in such a large transaction. In your experience, how often does something like this happen and just go uncovered?
Well, none of this should come as a surprise to anyone. I think the justification historically for some of the bank mergers was that we were going to take the advisory side, we were going to combine it with the investment side and a strong balance sheet, and we're now going to have an opportunity, at least this was the justification for some of the mergers, we're going to have an opportunity to pick up a fee on the advisory side, and then we're going to have the opportunity to also finance the deals. And I hate to use the word double dip, but that was the justification for some of these large transactions or these large mergers.
In recent years, it should come as no surprise to anyone that Wall Street has shrunk just in terms of the number of firms out there that can handle a $20 billion transaction. It's no easy going. That said, as we see further consolidation on Wall Street, do you think these types of conflicts are going to become more common? Is this going to be a larger problem going forward?
I think it's going to be a larger problem, both legally and practically. Some of the concerns are, boards develop relationships with their bankers. Mm-hmm. Let's face it, the confidence you have in your banker, your ability to communicate very candidly with the banker.
It's the way the industry works.
Exactly. The banker's ability to communicate candidly with you, the banker's knowledge of the business over the years is very, very important. And I think one of the concerns is that you may now see somebody looking to sell the company, looking at all the potential bidders out there, doing their due diligence, finding out who the financial advisors are, who holds large stakes in their stock. And if they see that at the get-go it creates a conflict for their own financial advisor, the financial advisor is going to be pushed aside in favor of some boutique advisor. Yeah, that may be a good thing for the boutiques. It may be a good thing overall, but I think that we need to be careful that we're not ignoring the value that's brought to the table with the historical relationships with your banker.
From a regulatory standpoint, this just has to be a nightmare for someone to take a look at this and try to figure out what can be done. What, in your opinion, should they do? Do we need rules to prohibit self-dealing from M&A advisors in transactions like this one?
I would strongly discourage any type of regulatory fix for this right now. This is a new and evolving process. We've only had a few cases where this has become the central focus. What I think we ought to look at is how the banks are going to deal with this themselves internally with regard to conflicts, how the court system is going to deal with it. I think the Delaware court is quite capable of dealing with the situation, and I think I'm always leery of knee-jerk reactions to one or two cases that present bad facts, because that's generally never good for anyone, and a one-size-fits-all solution generally causes everybody to lose.
In terms of broad targets, however, should it be more about trying to figure out a way to get firms to disclose when they're conflicted, or is the end goal something more like investment firms, much like law firms do, simply turn away work that they're conflicted on?
Well, it's happening now. You've seen dramatic changes in your engagement letters with banks now. Lots of changes as to what type of disclosure and what type of questions you're asking up front and the type of due diligence. So I do believe this will fix itself over time. It may ultimately come down to, like lawyers, you have to pick and choose a side.
Bloomberg reported earlier that law firm Wachtell Lipton was strongly against having Goldman in this deal, given their stake in Kinder Morgan. Why do you think it's so difficult for banks to adopt the same standards that law firms have? Are the industries, the legal services industry and the financial services industries, are they just so different that they're going to have to operate on different ethical standards?
Well, they're certainly different in the sense that, the lawyer conflicts really focus on the ability to communicate with your lawyer through a privilege, which you don't really have in the banking industry. And so I don't think that this ultimately gets to the level of the lawyers. The loyalty question is a little bit different. I think what you have now is you're still going to have resistance at the bank level to this, because it's important for the banks to show their names on the deal tables so that they have the ability to sell and get the next deal.
You were saying before that Goldman is entering a process where they're going to consider strengthening their internal rules regarding conflicts. What would you tell them if you were advising them on this?
I don't think I would purport to tell them anything other than I think I would probably tell them, as a view from 1,000 feet, the same thing I would tell anyone. Make sure that you're making full disclosure with regard to past relationships with potential bidders and investments with regard to potential bidders. And leave it up to the boards and their lawyers to decide how this all ought to ultimately be dealt with. Don't stick your nose into that process, because you don't want to wind up as a defendant. Let the board and the board's counsel make that decision.
Tough stuff. This is certainly going to take a while to play out, and I hope you come back and see us when there are further developments to discuss. John, thanks so much for coming in today.
Thank you.
That's John Reed, partner at law firm DLA Piper. If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com. You can also follow our updates on Twitter and see more of our videos on YouTube. I'm Pacchia. Thanks for watching.